Does not expect Trump to speak in the court because Trump failed to comply with the preconditioned terms by the deadline. He wouldn't agree to them. This is what we've learned. His attorney said he would not agree to them. CNN's Kara Scannell.
A sitting judge looked Donald Trump in the face and told him to stop talking, and the moment that happened, the whole illusion began to crack. It was not because the judge was angry. It was not because the courtroom was unfair. It was because Donald Trump, a man who has spent nearly 50 years surviving on confidence, spectacle, branding, and repetition, walked into one of the only rooms in America where none of that can replace evidence. That is what most coverage missed about Arthur Engoron's courtroom. This was not just another Trump courtroom drama. This was the moment a man's personal mythology collided with an institution that was not willing to treat his performance as truth. Now let's see why this courtroom moment revealed something much deeper about Trump's relationship with power.
Got the loans, they got paid. This is just an attorney general that hates Donald Trump. This is a case that should have never been brought, and I think we should be entitled to damages.
I focus on power, and more specifically, what happens when people who have held power for years begin to lose control of the rooms around them. What unfolded in Judge Engoron's courtroom was one of the clearest examples of that kind of collapse. On the surface, the case was about financial statements, inflated property values, business records, and bank fraud. But underneath the legal language, something much deeper was happening. This was about Trump's lifelong belief that his version of reality could dominate any room if he repeated it loudly enough. But in this courtroom, the usual formula did not work. The record mattered more than the performance. The judge mattered more than the brand. The rules mattered more than the speech. This part shows why the judge's warning was not just courtroom discipline, but a legal signal.
2 days into Donald Trump's first criminal trial, and he's already facing the threat of punishment if the judge determines he already violated the gag order put in place to stop him from attacking trial participants, including witnesses. He's also been warned about his behavior inside the courtroom, where, as we've reported, the judge was not happy with him muttering near a juror. Outside the courtroom, over the last days and weeks, muttering has...
The coverage most people saw focused on the loudest parts of the day: the clash with the judge, the speeches, the walkout, the press conference, the anger, and the spectacle. But those moments were not just random outbursts. They were part of a familiar Trump strategy. What looked like a loss of control was also a political performance. And the problem for Trump is that this particular performance had a legal price. When Judge Engoron warned him, he was not simply telling him to behave. He was building a record that could matter when calculating the penalty. That warning was not just courtroom discipline. It was a legal signal that Trump's behavior on the stand could cost him real money, real control, and real assets. That is why the reaction of Trump's own lawyers matters so much. They could not promise the court that he would follow basic yes or no testimony rules. Think about how serious that is. A legal team standing in front of a judge could not guarantee that their own client would answer simple questions in the proper format. That was not just embarrassing, it revealed the problem at the center of the case. Trump's lawyers knew that their client did not easily submit to authority he did not control. And inside that courtroom, he controlled nothing. Not the questions, not the record, not the judge, not the outcome. Here is where the case becomes clearer because the fraud finding was already settled before Trump spoke.
A judge has ruled that former President Donald Trump committed fraud for years while building his real estate empire.
This decision comes in a civil lawsuit brought by New York's Attorney General. The judge ruled the former president and his company deceived banks, insurers, and others by massively overvaluing his assets and exaggerating his net worth on paperwork. The judge ordered some of...
The most important detail is that Judge Engoron had already ruled on the underlying fraud before this moment ever happened. That is the part many people did not understand. Trump was not in that courtroom trying to prove that fraud had not occurred. The judge had already found that it had. The remaining question was the penalty. That means Trump's performance was taking place in a courtroom where the main legal question had already been answered. The trial was not about whether fraud happened anymore. It was about how much the fraud would cost him. That changes the entire meaning of Trump's speech. When he stood there declaring innocence and calling the case political, he was not making a successful legal argument. He was making a political statement inside a legal proceeding where the central issue had already been decided. The fraud finding was settled in that courtroom. The only remaining question was the size of the consequence. Trump knew it. His lawyers knew it, and that is why his decision to turn the moment into a grievance speech was so dangerous. Either it was a reckless legal mistake or it was a calculated choice to absorb legal damage in exchange for political content. Now watch how Trump turned a penalty hearing into a political stage.
We have a racist attorney general who's a horror show who ran on the basis that she was going to get Trump before she even knew anything about me. She used this to run for governor. She failed in her attempt to run for governor. She had virtually no polling. She came back and she said, well, now I'll go back to get Trump again. And this is what we have. It's a scam. It's a sham. Just so you know, my financial...
When Trump was given the chance to speak, he immediately turned the courtroom into a stage. He called the case politically motivated even though the judge had already ruled in writing that fraud occurred. The case was about the penalty, and Trump spent his time saying things that could make that penalty worse. That contradiction is the center of the story. It was not just a man losing his temper. It was a defendant behaving as if the rules of evidence and procedure were beneath him, while the court was actively deciding how severe the punishment should be. The legal structure of the case was clear. New York Attorney General Letitia James brought a civil case arguing that Trump and his businesses had repeatedly overstated the value of properties and assets in financial documents. These were not small differences or normal valuation debates. The claim was that the exaggerations reached into the billions. Judge Engeron reviewed the evidence and found before the penalty phase that fraud had occurred. That finding remained in the public record. It was not erased. It was not dismissed. It became the foundation for the penalty phase. The easiest way to understand it is this. Imagine someone tells a bank a property is worth $2 million, while independent appraisers say it is worth $400,000. The bank then makes financial decisions based on that inflated number. Later, a court determines that the number was fraudulent. At that point, the question is no longer whether the number was false. The question becomes what the consequence should be. That is where Trump was when he gave his courtroom speech. He was not relitigating the fraud finding. He was standing inside the penalty phase, and every evasive statement risked making that penalty heavier. This next section explains why evasive answers could become legally expensive for Trump.
The former president was defiant before he even took the stand.
We have to take away from the thugs that we deal with and the horrible people that actually must hate our country to do this.
Inside the court, things didn't go much better, as Donald Trump repeatedly assailed the judge hearing the case and the attorney general who brought the charges, calling it a very, very unfair trial.
The judge's warning about negative inferences was extremely important. It was not casual frustration. In a civil case, if a defendant refuses to answer direct questions or responds with speeches instead of answers, a judge can treat that behavior as meaningful. The court can infer that the honest answer would have been damaging. In simple words, if you are under oath and asked a yes or no question, but you refuse to answer directly, the judge can take that as a sign that the truth hurts your position. That can influence the penalty. 4 facts define the moment. First, the fraud finding had already been made. Second, the proceeding was about penalties, not guilt. Third, Trump's conduct on the stand increased his risk rather than reducing it. Fourth, his own lawyers could not assure the court that he would follow basic rules. That final point is devastating. It told the judge that even Trump's legal team could not fully manage him inside a proceeding where discipline was essential. For any defense lawyer watching, that was the nightmare scenario, a client giving the court more reasons to impose serious consequences. This was never just Trump against one judge. It was Trump against judicial authority itself. That is a pattern that has followed him for years. When judges rule for him, the system is fair. When judges rule against him, the system is corrupt. He has attacked judges appointed by Democrats, judges connected to cases he dislikes, and even judges from the conservative legal world when their rulings did not benefit him. The pattern shows up again and again in cases involving E. Jean Carroll, January 6th, immigration, business fraud, and beyond. Now see how the courtroom became part of Trump's media strategy.
Here about what exactly presidential immunity covers in the United States. Donald Trump's lawyers are arguing that he should not be facing these charges because he was acting in his official capacity as president at the time. Now, the three judges overseeing this case really peppered his lawyers' arguments with a number of questions, a number of hypothetical questions.
The pattern is simple. Trump enters the process appearing to cooperate. He shows up, files motions, and participates enough to seem engaged. Then, once the process refuses to give him the result he wants, he begins rejecting the rules. He gives speeches instead of answers. He treats procedure as persecution. He reframes the legal process as political theater. Then he leaves the courtroom and attacks the institution from the outside. He goes to the cameras, attacks the judge, attacks the attorney general, and tells his supporters that the entire case was rigged from the beginning. That is exactly what happened in New York. Trump appeared in court. He gave testimony. He turned answers into speeches. The judge cut him off. He did not return for the afternoon session. Then he went outside and attacked the judge, the attorney general, and the trial itself. But that press conference was not simply a reaction to what happened inside. It was part of the strategy. Trump often treats legal cases as political productions. The courtroom becomes the set, and the press conference outside becomes the real show for his audience. Even the sealed lips gesture outside the courthouse fits that performance. It looked like restraint, but it was content. It created an image. Then, inside the courtroom, the speech created a second image: defiance. The gesture and the rant were not opposites. They were two pieces of the same media strategy. One showed supporters that he was being controlled by a supposedly unfair system. The other showed them that he was fighting back. Both served the political narrative. But inside the courtroom, the legal record was still being built, and that record could become very expensive. This part shows why the stakes were not just about a fine, but about the Trump Organization itself. The stakes were much bigger than a normal fine. The Attorney General was seeking restrictions that could threaten Trump's ability to operate parts of his business in New York. This was about more than money. It touched the Trump Organization itself, the company that has been tied to his identity, reputation, leverage, and public image for decades. So when Trump called the trial boring, claimed it was a fraud against him, and attacked the Attorney General's motives, he was not helping himself in a penalty hearing. He was signaling exactly the things judges look at when deciding whether penalties should be severe. Judges care about remorse. They care about acknowledgement of wrongdoing. They care about whether the defendant appears likely to change future behavior. Trump's testimony showed none of that. No remorse, no acceptance, no promise of change. Every statement pushed in the direction of harsher consequences. He was not reducing the risk. He was confirming the very concerns that support a stronger penalty. Here is the detail that shows the pressure American courts are operating under. And then there is the detail that should have received far more attention. On that same morning, police responded to a bomb threat at Judge Engoron's home. This was not an abstract security concern. It was a threat at the judge's private residence. Yet Judge Engoron still came to court. He sat on the bench. He ran the session. He issued warnings. He told Trump's lawyers to control their client. He enforced the rules of his courtroom on the same day someone had threatened his home for doing exactly that. That image says more about the pressure on American courts than any simple headline about Trump clashing with a judge. What Trump revealed in that courtroom was not only contempt for the law, it was something more deeply ingrained. Trump has spent most of his life in rooms where his word carried unusual power. As a developer, he controlled the project. As an employer, he controlled the workplace. As a television figure, he controlled the image and delivered the verdict. In those environments, his version of reality often won because he controlled the room. A courtroom is different. In a courtroom, he does not control the exit. The judge does. He does not control the facts. The record does. He does not decide which questions matter. The legal process does. He cannot replace answers with speeches without consequence. If he refuses to answer properly, the court can punish that behavior. That is why the judge telling his lawyers to control their client was so revealing. It was a room refusing to bend. That moment tells us something larger about the world Trump has lived in. Fame, money, and political power have often shielded him from the kinds of ordinary authority that regular people face all the time. Most people who take the witness stand understand that they must answer the question asked. That is not complicated law. It is basic courtroom reality. Trump's resistance to that reality showed how rarely anyone has drawn a firm line and refused to move it for him. Finally, let's look at what happens next and why the penalty will become the real test. The reason this pattern will likely continue is that the political performance still works. By the time many people heard about what happened, the story had already been reframed as Trump fighting a biased judge. But the more important legal story was different. A defendant in a penalty hearing made his own exposure worse with every evasive speech. Inside the courtroom, the institution held the line. Outside the courtroom, the political narrative moved in Trump's direction. That gap between legal consequence and political performance is the heart of the problem. Think of it like a chess player who has always been allowed to change moves after placing the piece down. When someone finally says, "No, that move is illegal," the player does not experience it as fairness. He experiences it as an attack. That is the psychology that seemed to unfold in that courtroom. Rules that apply to everyone else can feel like persecution to someone who has rarely been forced to follow them. This matters because the civil fraud case established something serious. A former president and active political candidate was found by a New York court to have systematically misrepresented financial information to institutions. Not merely accused, not simply investigated, found in a written judicial ruling, and the penalty for that finding was being decided while the defendant struggled to follow basic courtroom procedure. The business consequences could extend far beyond the courtroom. Any bank, insurer, lender, or major institution considering future dealings with Trump can now review a public court record stating that his financial representations were found fraudulent. That is not just a reputation problem. It is a due diligence problem. The financial impact of that finding may last for years, no matter what final penalty number is issued, and the bomb threat should remain part of the story. People often describe Democratic decline in abstract phrases, norms eroding, guardrails bending, trust weakening, but this was not abstract. A judge's home was threatened. The judge still showed up. The courtroom still functioned. The rules were still enforced. And the defendant, whose business future depended on that process, spent the same day attacking the court's legitimacy from inside the courtroom and then outside in front of cameras. That is why the negative inference warning matters. The judge was not venting. He was creating a record. What comes next is not just a penalty amount on paper. It is a test of whether civil courts can impose real consequences on a person whose wealth, fame, political base, and media power have often been used to resist accountability. The first thing to remember is that the fraud finding already existed before Trump spoke. The hearing people watched was not a guilt hearing. It was a penalty hearing. The judge had already ruled that Trump committed fraud by overstating his net worth to banks and insurers by billions. So when Trump declared himself innocent, he was making a political argument inside a legal proceeding where the key legal issue had already been decided. Every speech, every refusal, every attempt to dominate the room happened while the court was deciding how much he should pay. The second thing to remember is that his lawyers could not control him. When the court asked whether they could guarantee that he would answer direct questions directly, they could not. That is damaging no matter how it is interpreted. Either Trump refused to follow legal advice, or his lawyers understood that he planned to perform regardless of the legal consequences. Either way, it told the court that the defendant did not appear fully committed to respecting the process. The third thing to remember is that the press conference was not an accident. Trump had two audiences that day. One was inside the courtroom, the judge, the record, the law. The other was outside, the cameras, supporters, and political base. The behavior that hurt him legally helped him politically. That is the trade. He absorbed courtroom damage in exchange for political spectacle. And because that strategy produced attention and loyalty, it will likely be used again. The fourth thing to remember is the image of the judge still running the courtroom after a bomb threat at his home. That is the real picture of institutional pressure. Not just headlines, not just drama. A court under threat still functioning, a judge under pressure still enforcing rules, a legal process continuing even while the political storm outside grew louder. Now the penalty is what matters next. If Judge Engoron imposes a penalty large enough to threaten Trump's business operations in New York, the next question is enforcement. A penalty being ordered is one thing. A penalty being collected is another. The space between those two moments will show whether the consequence is real or only symbolic. Also watch whether Trump's behavior on the stand appears in the judge's final reasoning. The judge warned that evasive conduct could draw negative inferences. If the final penalty order mentions that conduct, the warning had force. If it does not, the question becomes why the court made the warning on the record but did not rely on it. That will reveal a lot about how far civil courts are willing to go in a case involving a defendant with Trump's level of public power. And the biggest question remains open. If the penalty is strong enough to threaten the Trump Organization's existence in New York, what does Trump do when the business identity he has built his entire life around is placed at real risk? What happens when the buildings, the name, and the myth are no longer fully under his control? We do not know the answer yet. But the courtroom moment you just watched is where that answer begins.